This is SSCG14 Demonstrate Knowledge of the Criminal Justice Process. Part A. Explain an individual's due process rights. There are deep English roots in our legal system that come from the Magna Carta, the Petition of Right, and the English Bill of Rights. As colonists from England, they naturally adopted these protections for their colonial governments. A leading cause of American independence was that King George III tried to deny colonists their rights as Englishmen. In particular, the protections of trial by jury, prohibitions on excessive fines and bail, requirement that colonists be tried in their colony by a jury of their peers, and limits on search and seizures by English customs agents were all denied to colonists by the British government. After independence, the Anti-Federalists feared that the new national government would be just as inclined to violate individual rights as was the king. The new proposed Constitution permitted the national government to try individuals, which the Articles of Confederation never did. To get ratification in key states, the Federalists had to agree to amend the new Constitution with a Bill of Rights in the first Congress. Amendments, which address the rights of the accused, compose a large part of the Bill of Rights. The 4th, 5th, 6th, and 8th Amendments to the U.S. Constitution, along with certain safeguards in the U.S. Constitution itself, recreate the core protections the English system of criminal law derived over centuries of experience. In addition, Americans added certain provisions based on colonial experience with English overreach. The original Constitution prevents the national government and the states from making actions illegal after the fact, which is an ex post facto law. Criminal laws can only apply to actions after the law is passed. A bill of attainder, which legislatures vote to punish people through a legislative bill, is also prohibited for either state or national governments. Treason, which was a common charge in England at the time, is the only crime mentioned in the Constitution by name. The framers adopted a constitutional rule that 2 direct witnesses, or a confession to the traitorous act, was necessary for conviction. The Constitution also protects the Great Writ, as the writ of habeas corpus has been called. This allows prisoners to sue the government for their freedom with a judge to determine whether the prisoner is being lawfully held. The 4th Amendment governs how the government may collect evidence and arrest individuals. The balancing test of the 4th Amendment comes from requiring the evidentiary standard of probable cause. That is, the police must show, more likely than not, that the individual or the evidence to be seized is connected to a specific crime. The 4th Amendment's history comes from a legacy of the framers' history with the British Crown. Due to widespread smuggling and persistent refusal of colonists to convict individuals, the British Crown granted customs officials a general search warrant, good for the life of a king, to find smuggled goods, seize them, and apprehend the suspects. As these agents often collected part of the seized goods' values as pay, their enthusiastic searches and seizures affected and irritated American colonists. For this reason, the 4th Amendment prohibits general searches, but requires the evidence or person to be seized be named in particular, and requires establishing probable cause prior to the search that a crime has been committed. Independent judges issue search warrants or arrest warrants with law enforcement officers required to swear that the facts used to gain the warrant are true. Warrants are not always required when the Supreme Court and lower courts decide that a search did not occur within the 4th Amendment's protections, or that exceptional circumstances exist under the 4th that do not require a warrant. If no search is involved that implicates a person's privacy, then probable cause standard does not apply. If there is an exception to the 4th Amendment, the primary purpose of the exception is not to grant law enforcement the power to evade warrants, but to address important interests of society. One such example is a special places exception. Police may check people's handbags before they enter a prison, because contraband, such as drugs or weapons for prisoners, may be brought to them by outside visitors. Key cases on warrantless searches under the 4th Amendment include Katz v. U.S., Terry v. Ohio, and Carroll v. United States. Katz was a gambler that conducted his illegal business in a public phone booth owned by the telephone company. A microphone was installed in the booth and was only activated when Katz entered to make or receive a call. As the phone company owned the booth and the booth was in public use, law enforcement argued a warrant was not required to tape Katz making calls. The Supreme Court disagreed and made a reasonable expectation of privacy the new Fourth Amendment standard, instead of the older one requiring trespass. The court claimed Katz had a reasonable expectation of privacy when he placed a phone call from a phone booth designed to create privacy. Wiretap intercepts of the phone call required a warrant, and so did recording someone when they make calls or attempt to preserve their privacy, regardless of who owned the phone booth or whether the public had access. Mr. Terry and two others were stopped by an experienced plainclothes police officer in public. Officer McFadden felt Terry and his companions behaved oddly in front of a jewelry store, and could state specific facts underlying his suspicions that they were casing the store for robbery. Officer McFadden then approached the individuals, engaged them briefly in conversation, and based on their suspicious answers, stopped and frisked the individuals. He found two of them had firearms. The individuals were detained and later charged with being felons in possession of a firearm. The Supreme Court addressed whether Officer McFadden required a probable cause to make an investigative stop that involved frisking and a brief interrogation in public of these individuals. The case creates a reasonable suspicion standard of evidence so the police can make brief investigatory stops in public to thwart potential crimes and to protect public safety. This standard is lower than probable cause, but requires officers to present articulable objective facts supporting a stop to a judge who determines whether the stop was legal. Carroll is a bootlegging case where the police stopped a vehicle on a public road to determine whether or not the vehicle held illegal moonshine. The court ruled brief stops on public roadways by police are permitted without warrants. Police may stop vehicles to determine whether the driver possesses the proper permits and licenses and is safely operating the vehicle. Since the stop is in public and a driver operates a potentially dangerous vehicle on public roadways, the court felt requiring a warrant for all stops was unnecessary. The court held the public's interest in roadway safety outweighs the inconvenience of the individual being stopped. The Fifth Amendment protects the right for suspects not to answer questions, requires a grand jury indictment for all felony charges, prohibits double jeopardy, which is repeatedly trying an individual for the same crime, hoping for a conviction, and the Due Process Clause protects the accused by making sure that all individuals charged with a crime are given the same fundamental rights and procedures that others enjoy. Suspect confessions in history were often obtained by torture, physical abuse, or simply psychological abuse over long periods of time. Given the imbalance of power between a jailer and its prisoners, the Fifth Amendment attempts to prevent the state from taking advantage of the prisoners and coercing them into testifying against themselves. Grand juries are employed in our system so as to not give prosecutors unfettered discretion to charge an individual with crimes. Using the probable cause standard of evidence, grand juries collect evidence and testimony before them and reach a decision whether an individual should be indicted or not. While the prosecutor serves as a legal advisor to the grand jury and as the presenter of evidence before it, the prosecutor does not actually get to vote on whether a bill of indictment is issued. The Fifth also prevents repeated trials on the same offense after a jury renders a verdict of not guilty. This is to prevent the state from harassing someone using the legal process to do it. Along these same lines, trials require common rules for procedure, which serve to protect basic constitutional rights, as well as the right to a fairly conducted trial that is not designed to automatically convict individuals accused of crime. This slide summarizes the Fifth Amendment's protections. The case of Miranda v. Arizona requires police to advise suspects of their rights upon being taken into custody or otherwise interrogated while being detained by police. While the Supreme Court has refused to strictly define the exact words of the warning, defendants must be advised that their answering of police questions is voluntary, and testimony given to the police may be used against them. Similarly, suspects must be advised of their right to an attorney to act for them, even if they cannot afford one, because the state will provide one to them in that case. A defendant being represented by an attorney during questioning, who knows how police operate, can provide significant psychological support for an accused suspect. Attorneys also carefully advise their clients when and how much to tell the police. If the police do not give a Miranda warning to suspects, they risk that any statement by the defendant may be suppressed as illegally acquired evidence. To avoid this, the police have the burden to prove the defendant talked with the police knowingly and willingly with no coercion. The Sixth Amendment outlines the key constitutional protections for the accused during the criminal trial process. The government cannot hold the accused forever in jail, waiting for a trial, nor can the government try the accused in private because of a right to a public and speedy trial. Also, juries and judges must be impartial and come from the state and district where the crime is alleged to have occurred. Defendants are entitled to full discovery of all the evidence that the state will introduce at trial, and the specific charges in law that the defendant is alleged to have committed. The prosecution's witnesses must testify in open court with the defendant present, and these witnesses are subject to cross-examination by the defense. Witnesses for the defense can be issued a court subpoena that orders them to testify on the defendant's behalf. Defendants are entitled to have a lawyer present their case. If they cannot afford one, then a defense counsel will be appointed to represent them at all stages of the legal process. The Eighth Amendment institutes the idea of proportionality in punishment and gives defendants a reasonable chance to post bail and be released until trial. This amendment allows judges to permit whether an individual is a flight risk due to previous conduct or the severity of the charge, and also permits the judge to take into account the financial resources available to the defendant. Ingenuity in punishment creates the risk of disparate and cruel punishments that have been meted out in the past, such as starving defendants to death, drowning them, etc. Punishment should be viewed as rectifying the offense and not from governmental cruelty. In 1958, the Supreme Court decided that current societal standards defined what is cruel and unusual punishment in Trott v. United States. Later, the Supreme Court used two Georgia cases in the 1970s to determine whether a death sentence violated the U.S. Constitution's Eighth Amendment ban on cruel and unusual punishment. In the first case, Furman v. Georgia, a split Supreme Court decided the implementation of the death penalty in Georgia and other states violated the Due Process Clause because of the possibility that an innocent person could be put to death, and that the punishment was often not proportional to the crime. However, 4 years later, the Supreme Court upheld Georgia's revised death penalty law in Gregg v. Georgia as constitutional because of the additional due process protections and limits on its use to cases involving murder in a particularly callous and heinous fashion. The 14th Amendment Due Process Clause allows the federal government to require the states to guarantee fundamental constitutional rights. Under it, states must protect U.S. constitutional rights of the accused. The application of the 14th Amendment's provision to the states involves criminal justice matters, begins with infamous cases involving gross legal improprieties in state criminal trials that violated fundamental rights to a fair criminal justice process. A Reconstruction-era law under congressional power to enforce the 14th Amendment is Section 1983 of the U.S. Code. This makes state and local officials liable for damage lawsuits if those officials illegally act to deprive individuals of their rights under the Constitution and laws, both federal and state. A matching law under Section 242, Title 18, allows the federal government to file criminal charges against state or local officials that purposefully violate an individual's federal constitutional or statutory rights. Other remedies for a violation of constitutional rights, particularly on search and seizure or illegal interrogations, permit the trial court to suppress illegally obtained evidence, which can result in a dismissal of charges or a new trial. Gross misbehavior by law enforcement officers can also result in them getting personally sued for violation of constitutional rights. However, judges and prosecutors have absolute immunity from civil and criminal liability, and police have qualified immunity protections which make lawsuits alleging misconduct of the police more difficult when gross negligence or criminal misconduct is absent. U.S. v. Leon reduced the scope of suppression motions by allowing law enforcement to raise the issue that their violation of constitutional rights was inadvertent and not due to police misconduct. Technical errors in the warrant that was served were the fault of a magistrate's clerk, and these were held by the Supreme Court not to require suppression of evidence gathered under the technically incorrect warrant. Sources for this module. Sources of images for this module. Additional resources for criminal justice legal issues. This concludes this content module.